and was to speculate as to her actions. In the case of Karim, the trial court there said, failing to differentiate the elements and the evidence which supports each element, the defendant must meet their burden in each element. We can't just look at a case and look at the facts of the case and say that because a plaintiff may have been negligent, that means that they were also the cause of the crash. There must be more. The Court of Appeals implies that the facts of the speed, the line of sight, the color of the light, and the exhibits of the intersection and vehicles was enough to create an opportunity to avoid the crash. But the only way to come to that conclusion is to speculate where or what Miss Drain could have done to avoid this collision. To support that, the defendant had the burden to produce evidence to demonstrate at what point a recently proven person in the plaintiff's circumstances, exercising ordinary care, should have realized
your
that
skin,
the
make you
defendant was
look
going
young,
to
and those
continue
plastic
to turn
noses.
across
But I got
the
a
lane,
cute nose.
and whether at that point the plaintiff could have taken action.
Make me look
You
about
know
10
those
years
plastic
It's our
nose things
position
go dead up in your
that
Oh.
nose
Miss
all
Drain
the way
so far
back
into the
here.
intersection,
Oh.
almost
Yeah, when they be pulling
completed her route through
them
the
things
intersection.
out,
There was nothing
things
she
were
could
weird
do
as
to
hell.
avoid the collision. It was going to happen. She
Yeah,
couldn't
you
do
made her
anything about it.
scissors.
In the courts, both the trial court and the Court of Appeals never looked at proximate cause and the evidence that may support it. It's position to say that the facts of a negligent action
Oh, it's
are
Haley.
enough for causation
Congratulations,
as well
Haley.
is fatal to negligence cases across the Commonwealth. If this opinion stands, then defendants would be held really to a lower standard than what
Not
is
sure who
required.
this is.
They wouldn't be required to address each element and have each
I'm
element
hoping it's
present
after
for
this
evidence,
one.
for
They're
that
arguing
contributory
for 10
negligence
minutes
standard,
each.
or for contributory negligence defense to be submitted to the jury.
Congratulations.
Furthermore, there was an issue in discovery where the defense of contributory negligence was not disclosed.
My connection
and the
is slow.
support for the defense was not disclosed in discovery. Discovery is a critical part of litigation, and supplementation to discovery is a critical part of litigation. The petitioner was not made aware that the defendant was going to rely upon contributory negligence as it asked for in discovery. Those the answer
They
to
do argue for
the
10
complaint
minutes.
was it may
Of
if facts come to light. But when asked in discovery, there was nothing.
course, this is about
There was
Lulu.
nothing that made the petitioner believe
We needed to go
that the
back.
defense of contributory
Y'all,
negligence would be relied
needed
on,
to
and
go
no
back.
No facts were set forth. The petitioner was prejudiced by the last-minute reliance when she found out when jury instructions were exchanged.
I would tell Tyreek, but he hasn't fucking
approximately
talked to me.
36 hours before the trial started. What's
Oh,
most bothersome is the
my big
reliance of the defense of contributory negligence was opposite of the representations made that Pantana was the sole cause of the crash. Pantana confirmed she was the sole cause of the crash. She confirmed that she knew of no other fact that would be considered or that would consider Ms. Drain contributorily negligent. And for those reasons, the plaintiff
I
was
can't hear anything like
prejudiced
you're live.
when we got to trial.
well, I see the
We
little
were
green
surprised by
things
the
moving.
defense that was coming up at the last minute. And finally, Dr. Bender, a neuropsychologist, was allowed to testify as